Hi everyone, this is Pennsylvania attorney Evan Gutman with video number 21 of my video legal education series, which is based upon my book, State Bar Admissions and the Bootlegger's Son, available on both of my websites, which are gutmanvaluations.com and heavensadmissions.com. Both of those websites also contain two other books I wrote. One is a supplement to State Bar Admissions and the Bootlegger's Son. The other is a fictional novel titled Heaven's Admissions Process. It's a somewhat comical fictional novel that compares the criteria for being admitted into heaven with the criteria for obtaining a law license on earth. If you're viewing this on my Facebook pages, there should be a link to the written material for a PDF related to this video. The chapter is titled The Days When U.S. Supreme Court Justices Raised a Little Hell. And I also have a YouTube page which links to my websites in addition. I have two Facebook pages. One is my personal page, which this will be on, and then the other is a separate Facebook page, which is titled Judicial Constructive Criticism Network. And the YouTube page is titled the same way. It's Judicial Constructive Criticism Network. So the purpose of this chapter today, this video today, based upon chapter 21 from my book, as stated, it's titled The Days When U.S. Supreme Court Justices Raised a Little Hell. And I'm going to examine the background and life of two very prominent U.S. Supreme Court justices in this video, and then part two of this chapter will be in the next video, where I'm going to examine the lives of a few other justices. And the reason I'm doing this, it shows that basically, everybody's got issues in their life. And the state bars are in no position to be taking certain things with respect to a person that are not based upon objective conduct, but simply reflect their life circumstances. And you will see as I discuss some of the things in this chapter that it's quite questionable whether if these justices in today's world would pass the good moral character standard for admission themselves based upon their own life's experiences. And whether they are reflective of positive or negative character traits, one thing is for certain, they are definitely very interesting. So the first justice, who is actually my hero, is Justice William O. Douglas. He served on the U.S. Supreme Court longer than anyone, from 1939 to 1975, which is 36 years. He wrote an autobiography, and his autobiography reflects his personality just by the title. We've all heard the saying that goes, "Go west, young man." It's an old saying, the concept being if you want to find your life and have some excitement and fun, go west, young man, to where the excitement is, kind of referencing back the cowboy days from the 1800s, maybe even early 1900s. Well, Justice Douglas's autobiography does the exact opposite. He grew up in Yakima, Washington State, Yakima, Washington State, way out west. And his autobiography is titled Go East, Young Man, which I love. And it's a great autobiography that I highly recommend. I'm going to talk about some of the things he writes in his autobiography. He tells about his childhood. And he grew up quite poor in Yakima, Washington. And he writes as follows about that experience. While there were many children's parties in Yakima, we were never invited to a single one, and we were far too poor to have one in our own home. In the after years, I thought it was a blessing that I had not. For if I had been united with the elite of Yakima, even by so tenuous a cord, I might have been greatly handicapped. To be accepted might then have become a goal in later life, an ambition that is often a leveling influence. In other words, it's not that important to be accepted by others as long as you feel good about yourself. As a teenager, he became what is known as a stool pigeon for the local police department. And what he was supposed to do is described as follows. Would I, for $1 an hour, spend Saturday and Sunday nights working Front Street? My instructions were, see if you can get a woman to solicit you. See if you can buy a drink from someone. When the night is done, check in at the office, execute an affidavit, and the police will move in. And so a teenage boy became a stool pigeon in the red light district. Never did I have such a shabby feeling, and in the end, never did I feel sorrier for people than I did for those who I was supposed to entrap. As a side note, when he became a justice, he was probably the most staunch civil libertarian and supporter of the poor and the impoverished, as well as civil rights and minorities, than any other justice ever. He then went to Columbia Law School, but to get there, since he had no money, he did have a scholarship to Columbia, but he didn't have money to travel across the country. So to get to Columbia Law School from Yakima, Washington, he hopped a freight train. When he got to New York City, he wrote as follows about his early life experiences as a young man. In New York City, drinking was the thing to do. So I started taking a few drinks, mostly of miserable gin. After I got to Columbia, I also tried very hard to learn to smoke cigarettes. Having acquired the habit, however, I became an inveterate smoker. I became so accomplished, that's the word he used, I became so accomplished that I could smoke 3 packs a day. While at Columbia Law School, he got a C in constitutional law, even though he is widely regarded by many, including myself, as the most prolific U.S. Supreme Court constitutional scholar ever. At least that's how I see it, and many other people do also. Both Justice Douglas as well as Justice Hugo Black, they consistently ruled in favor of the applicants in state bar admission cases, and their opinions are absolutely fantastic. As showing his sensitivity to the poor, he writes as follows in his autobiography. Never did I dream that I would live to see the day when a court would hold that a person could be too poor to get the benefits of bankruptcy. Yet in 1973, the court in United States v. Crass held by a 5-4 decision that an indigent who could not pay the bankruptcy filing fee could not be discharged of his debts. He writes about how he had polio when he was a child, and he was so physically weak, but ultimately it strengthened him as an individual. He describes how his polio experience as a child became a catalyst for him in life as follows. But my rebellion against the shame of being called a weakling had lasting effects. As already noted, it caused me to become very much a loner. Moreover, it inured me in a subtle way to all criticism. Not that I enjoyed criticism. I certainly did not, but criticism never made me turn and run. Rather, it impelled me into the thick of the fight. He was married 4 times and divorced 3 times. At age 70, he married his 4th wife, Kathy, a law student at American University. His children came to resent him because I guess it is multiple marriages, somewhat understandable. But his children came to resent him. Nevertheless, he wrote as follows in his autobiography. Few people I have known are competent to be parents. I doubt if I rated high as a father, although I did receive a Father of the Year award once. He described a fellow justice on the court, U.S. Supreme Court Justice Charles Whitaker, in a quite critical manner. In one case, Justice Whitaker was assigned to write the opinion for the majority, and Douglas was dissenting. Whitaker was having trouble writing the majority opinion. Since Douglas knew the case so well, he took the incredible step of offering to help Whitaker write the majority opinion, which Whitaker accepted. The case was Meyer versus United States, And although Douglas did not sign the majority opinion because he dissented, he became known as one of the few justices who wrote both the majority opinion and the dissenting opinion, but he didn't sign on to the majority opinion. When the other justices of the Warren Court in the 1960s, which was the great civil rights court, wanted to get additional law clerks, Douglas teasingly countered to them with a suggestion to abolish all law clerks. And he said, quote, "Why don't we experiment with doing our own work? You all might like it for a change." I love this guy. Justice Rehnquist, William Rehnquist, who was an ultra-conservative justice and chief justice of the court, when he served with Douglas before Justice Rehnquist became chief justice, he once said that Douglas seemed disappointed if the other justices agreed with him because he therefore would be unable to write a stinging dissent. Once Douglas said to Justice Rehnquist, who was then by Chief Justice, he said, "Chief, for the reasons you have so well expressed, I vote to reverse instead of affirm like you do." One of the most interesting things about Douglas is the end of his career, and it's sad, and it's an incredible event at the U.S. Supreme Court, absolutely incredible. In 1974, Douglas suffered a debilitating stroke on New Year's Eve. He tried to return to the court in 1975, but he appeared half crippled, unable to remain alert, and incapable of speaking clearly. Nevertheless, he refused to resign. And what happened was unbelievable. Since the other justices didn't feel he was competent at that time, they engaged in a secret agreement that no case would be decided 5-4 if Douglas were in the majority. They didn't want Douglas to have the deciding vote in any case of any nature. This policy that they secretly agreed upon without Douglas's knowledge would be invisibly enforced by simply ordering re-argument in any case where Douglas held the decisive vote. All of the other justices agreed to this with one exception, and the one exception was Justice Byron White, also known as Whizzer White. Justice White objected to this quite nefarious and deceptive tactic on the part of 7 other U.S. Supreme Court justices, and he wrote a letter that was not discovered until like 2001 or 2002, when White's papers were released. He wrote as follows: "Dear Mr. Chief Justice, I should like to register my protest against the decision of the court not to assign the writing of any opinions to Mr. Justice Douglas. In this instance, the action voted by the court exceeds its powers and perverts the constitutional design. If the court is convinced that Justice Douglas should not continue to function as a justice, the court should say so publicly and invite Congress to take appropriate action." That's quite an incredible letter, and it's, like I said, it didn't come out until decades after it was written. Suffice it to say, it was sufficiently deceptive and nefarious that if it were done today, these 7 of those justices would not be able to gain admission into the state bar. The next justice I want to address here, so that's the story of Justice Douglas. I love the guy. He's fantastic. The next justice I want to address here is known as Stephen Field, Justice Stephen Field. He served as a justice in the 1800s, shortly after the Civil War. If ever Hollywood producers make a movie about Stephen Field, I don't know whether he should properly be called a Supreme Court justice or a cowboy. Unbelievable guy. This story is incredible. He served during the court, and he actually was the author of the main case that holds the right to have a law license is a right rather than a privilege. Ex parte Garland stood for the fact that a law license is a right, not a privilege. Now, before he became a U.S. Supreme Court justice, when he was a trial court judge, he didn't get along with some of the other justices, to state the matter mildly. This is the following story that is about in his biography, not an autobiography, it's a biography. And this is quite interesting. In 1850, the new district court judge, William Turner, replaced Field as the highest judicial authority. It was not long before the two men clashed. On June 7th, Field said something that irritated the new judge. The new judge held Justice Field in contempt of court. Not the first time, by the way, he would be held in contempt of court. Field claimed that Turner was prejudiced against him because he was from New York. Turner claimed that Field was disrespectful in court. So what happened was another judge then ordered Field to be released after Judge Turner had him arrested. A mob then came to the courthouse and they threatened to throw the judge who had Field arrested into a river. This is like the Wild West, 1800s, 1860s, 1850s even. So Turner then held the other judge who released Field in contempt and ordered Field to be disbarred. Field was in fact disbarred. He later appealed and won, and he was reinstated to the bar. But then the other judge disbarred him again. So you can see it's like going back and forth, and it's power. But the thing that's interesting about this is Justice Field, who wrote Ex parte Garland as a U.S. Supreme Court justice, holding that a law license is a right, not a privilege, he was in fact held in contempt twice and disbarred twice. And that is not the only thing. As incredible as that story is, the next story about him is even more incredible. This story is absolutely unbelievable. In 1862, Field was Chief Justice of the California Supreme Court. And the California Supreme Court was ordered to send its files up for review to the U.S. Supreme Court. Field refused to comply with the U.S. Supreme Court order and held that the Supreme Court of California does not recognize an unlimited right of appeal to the Supreme Court of the United States. But here's where it gets real good, is the Terry incident. The Terry incident is amazing. What happened was, just when Justice Field was a U.S. Supreme Court justice, his bodyguard shot and killed former California Supreme Court Justice David Terry. What happened was, that gave rise to this, was that Terry, who by that time was off the California Supreme Court, and prior to being shot and killed, obviously, Terry had represented a woman named Sarah Althea, and she was rumored to be a prostitute, and Terry represented her in a lawsuit against a U.S. senator. The woman contended that the U.S. senator had kept her as a mistress and had contracted to marry her, so David Terry's representing her. Well, the case goes to a California court, and a judge named Judge Sawyer rules in favor of the U.S. senator. Sarah, the woman, rumored to be a prostitute, physically attacks the judge. Like I said, this is the Wild West, 1860s. Justice Field, then takes the case over from Judge Sawyer, because he's not yet a U.S. Supreme Court justice. And he also rules in the U.S. senator's favor. The woman, Sarah, rumored to be a prostitute, then starts yelling in the courtroom that Field had been bribed, and Field orders her removed from the courtroom. The woman, Sarah, slaps the marshal in the face who's trying to remove her. And by this time, Sarah, the woman rumored to be a prostitute, she's now married to David Terry. Terry says, "Don't touch my wife." The marshal does not relent, and former California Supreme Court Justice David Terry punches the marshal in the face. Well, ultimately, they get released from jail. Released from jail. David Terry did serve 6 months in jail for contempt, But ultimately, he does get released, and he's with Sarah, the woman rumored to be a prostitute, and they find themselves on a train with Justice Stephen Field, who by this time is a U.S. Supreme Court justice. What happened at that point in time has long been the subject of dispute. It's questionable whether Terry attacked Field or whether Field started the whole thing. In any event, what ended up happening is Field's bodyguard, David Nagel, ended up shooting and killing former California Supreme Court Justice David Terry. And that case itself ends up going to the U.S. Supreme Court because the crux of it was that whether Nagel had immunity in his role as a bodyguard to protect a U.S. Supreme Court justice. And the court, since it's the U.S. Supreme Court, which Justice Field is on now by that time anyway, the court basically does hold that David Nagel, the bodyguard, had immunity to protect Field, and he was justified in killing former California Supreme Court Justice David Terry. So it's easy to see why the state bars do not like Ex parte Garland, the opinion that Field authored. I can only imagine how they would treat a state bar application on moral character from Justice Stephen Field. He was disbarred twice, held in contempt twice, at least twice. He was arrested for murder on one occasion, which was the David Terry incident, but he was ultimately released because David Nagel was found to have immunity. And the Terry incident established the doctrine of immunity from prosecution for federal officials carrying out their official duties, as the charges against Nagel were ultimately heard by the U.S. Supreme Court, and he won. Justice Stephen Field, absolutely incredible. And Justice William O. Douglas, my favorite justice of all. Anyway, that's today's presentation. A little bit longer than other ones, but these two individuals are so worth the time to talk about. Anyway, have a good one. We'll have the next video on within the next few days, 3, 4, 5, whatever. And remember, love right, don't fight. Bye, everybody.